Good morning, Ms. Kaiser.
Good morning, Your Honors. May it please the Court. I'm Jean Kaiser, and I represent the juvenile in this case, and we would respectfully ask this Court to reverse the finding of delinquency on the count of mayhem for two separate but related reasons. The first reason is that there was insufficient evidence to prove one element of the crime, the specific intent to disfigure or maim beyond a reasonable doubt. The second is that the juvenile received ineffective assistance of counsel. With regard to the specific intent to maim or disfigure element, the appeals court has cautioned that although every assault and battery with a dangerous weapon contains the possibility of serious and lasting injury, not every assault and battery can be mayhem. And
counsel, what about every time someone is set on fire? Can't we focus in on the fact this was a fire, and that when a person puts lighter fluid or flammable fluid on another person and then they strike a match and set them on fire, it's likely to disfigure or maim?
Your Honor, I would agree if the defendant here was an adult, that would most likely be the case, that you could infer the intent there, because the requirement when the action is a single act is that there be a reasonable appreciation that the action will result in a disfiguring injury. However, here the defendant, or the juvenile, was a 10-year-old boy. And
so what?
Well, I think with a 10-year-old boy, I don't think we can infer that he would have a reasonable appreciation that what he did would result in a severe and disfiguring permanent injury. I think that it is fair to assume...
Can't we agree that a 10-year-old would know fire burns?
Yes, we can, Your Honor. I think that's a fair assumption. But there's a difference between the general knowledge that fire burns and the knowledge that a burn will leave a lasting scar, and that is what is specifically required by the mayhem statute, and that is the problem here.
I'm not sure that I understand, I haven't read the record yet. Was he playing with burning ants and roaches? Was there evidence that he was playing with burning ants and roaches before, or was that just something that came in, that didn't come into evidence?
That did not come into evidence, Your Honor. Really, all that came into evidence was the testimony of the victim was from the moment that he encountered the two boys and what happened from that point on. So the surrounding circumstances didn't come into evidence.
As I understand the case, that burning the ants and all that stuff is extraneous. That was not, as you said,
it was not before the jury.
Part of the evidence. The best you can get out of this is a new trial, I take it.
That's correct, Your Honor.
Yeah. The judge, I guess you say, should have instructed there was a jury?
It was jury.
Instructed the jury that someone who is under the age of 14, between 7 and 14, there's a presumption they can't form the capacity to do the crime. That was never done?
Well, Your Honor, I'm not sure. The whole infancy defense, the presumption, rebuttable presumption that a child under 14 can't form the intent to commit the crime, that is an unclear, the status of that is, I think, unclear under the law of the Commonwealth. But it's our position that even the rebuttable presumption, it wasn't necessary to find that the juvenile didn't commit the crime here or didn't fulfill the specific intent requirement. If you think about a tort case, a jury is instructed when a tortfeasor is a child that they should be judged against the age and experience of other children their age, not by the adult standard. And that wasn't done here. The jury was instructed, got the same specific intent instruction on the mayhem count that an adult would have received.
Did the juvenile request an instruction on specific intent as it applied to him?
No, the juvenile did not instruct such an intention, but that goes to the ineffective assistance of counsel claim that is also a part of this case. The trial counsel did really almost nothing for the juvenile. The only strategy that I can discern from looking at this record that trial counsel had was to try to prove that the juvenile friend was the one who spilled the dry gas on the child, and that because of that he couldn't be held, that the juvenile couldn't be held accountable for either mayhem or assault and battery with a dangerous weapon.
Wouldn't that be an alternative that would be inconsistent with arguing that he lacked the specific intent to maim? If he were trying to convince, this was a jury trial, right?
It was.
If he was trying to convince the jury that he didn't do it, that his friend did it, then wouldn't it be sort of awkward to say, but if he did it, he didn't have the specific intent to maim?
No, Your Honor, he didn't argue that he didn't seem to present any evidence. He didn't present any evidence or even cross-examine the victim as to whether he was sure it was the juvenile, my client, who threw the burning piece of paper at him. What he did instead was, it appeared that the cross-examination was designed to show that the other child threw the gas and that perhaps my client threw the paper and that somehow that exonerated my client. But just a reading of the statute shows that defense betrays a fundamental ignorance of the law.
Can I back up a little bit? Why do you think the law is unclear on the presumption between ages 7 and 14? I thought Commonwealth versus Meade more or less said it's our law.
Well, it does, Your Honor, but the presumption has seemed to have made cameo appearances throughout the court's history. And the most recent cases, it seems, deal with the question of the presumption in relation to rape. And in those cases, the court is...
Those are a little muddled because they're talking more about physical incapacity to do the act rather than the intent.
That's right.
Correct?
But in any event, there may be a presumption that is overcome in those circumstances. As I understand the physical evidence at the rape trial, it was clearly overcome.
That may well be so in that particular case. In this case, I don't think any presumption was overcome. I would argue that, in fact, even without a rebuttable presumption that...
I understand, but we're going to, assuming that we decide that a new trial is required, assuming, you're saying all I want is an instruction on specific intent, which addresses the situation. Trial counsel did not ask for that. That is different from the so-called infancy defense, and trial counsel, I don't know if you'll be trial counsel, is going to ask the judge to instruct on an infancy defense because it's now front and foremost.
Well, Your Honor, let me clarify my position. I think for this court to send the case back to the juvenile court, it's not necessary for the court to affirm that there is an infancy defense in which there's a rebuttable presumption that must be overcome. However,
I don't understand that. Why not? Why not?
For two reasons, Your Honor. First of all, I think that the court should find that the juvenile received ineffective assistance of counsel that would entitle him to a new trial.
I understand that. I'm assuming that we're past that. And
okay.
Then the next thing that happens is you get a highly effective trial counsel who says, Your Honor, there are two things I want here. I want a specific instruction on that there has to find specific intent, and I also want that to be added to that an infancy defense.
Well, of course, Your Honor. Again, let me clarify. I think to send the case back, it's not necessary that the court affirm there's a rebuttable presumption, but would I request that you do find such a rebuttable presumption? Absolutely. I think the rebuttable presumption in cases like this where the child is under 14 could play an important role in assuring that children who are not culpable don't receive what essentially amounts to punishment along the same lines.
What's the status of this whole rebuttable presumption stuff throughout the rest of the country? Do we know that?
It's divided, Your Honor. I think I would have to admit that most states at this point are not applying a rebuttable presumption, but some states still do or are returning to it. And the reason for that is that when the juvenile courts came into being, the theory was that now we have juvenile courts, and what will happen to juveniles who are accused of criminal behavior is that they won't be punished, they'll be treated. It's not a punitive situation. However, as time has gone on, we've seen that really there is a lot of equivalence between what happens to juveniles who are in the juvenile court system and what happens to criminal defendants who are in the adult system. You can call a juvenile facility a school or a treatment facility, but the net effect of what happens to juveniles in those situations is, in fact, that it's a form of imprisonment.
Do we know what the model penal code does with this so-called issue of incapacity among young people?
Your Honor, I don't know. That's certainly something that I could supplement on.
Can I ask you this question? Explain to me precisely what the rebuttable presumption is. Rebuttable presumption of what?
Your Honor, at common law, there was a presumption. Well, there was a unrebuttable presumption that a child under 7 did not have the capacity to form the intent to commit a crime.
So it did not have the capacity to form the intent to commit a crime.
Right.
It's manslaughter. It didn't have. It's general intent, manslaughter.
Right.
Under 7, no manslaughter.
Right.
Therefore, cannot be held criminally
Between
liable.
7 and 14, a presumption that he...
Did not.
Did a presumption that the child could not.
That could be very pertinent in this case, because here's this kid, he's 10 years old, admittedly a very bad act, but, you know, the mind of 10-year-olds vary, and it could well be, he said, oh, you know, we'll do this kind of thing and just see if there's a fire that starts. But he's specifically got to know that it's going to seriously burn and injure this other child.
Well, that's right.
But this kind of presumption, if we agree with your position, would apply to other cases. Am I correct?
That's correct, Your Honor.
And given the fact that it appears to me, I haven't done any studies, but maybe you're aware of some, but it seems to me that young people, 12 and 13, are committing crimes, much more serious crimes than they did 20, 30, 50 years ago when there were these types of presumptions. You read now about people on bicycles shooting people and riding their bicycles away because they're too young to drive.
That may be the case, Your Honor, but it's a rebuttable presumption.
But wasn't the rebuttable presumption created at a time before there was such a thing as juvenile delinquency?
That's correct, Your Honor, and that's why it seems to have gone out of favor and now seems to be making somewhat, I would say, of a resurgence because of the history of the juvenile courts. At one time, the punishment for many crimes was the death penalty, and that seemed harsh for a child who may not have been able to form the intent.
Well, we now know that that's unconstitutional.
Right. But with regard to Justice Cowan's question about, well, what do we do about children who commit serious crimes and they're under the age of 14, the rebuttable presumption allows the jury and the court to consider the age of the child and create a presumption that the child was not capable of forming the intent. But the Commonwealth certainly can rebut that presumption, so to take care of any concern that children who truly are culpable. And hopefully, Justice Cowan,
How do you rebut the presumption?
Well, you can do it, in this case, interestingly, the Commonwealth possibly could have rebutted the presumption if the trial counsel had done what I think he should have done, which is to get an expert to examine the child or to present evidence of what a 10-year-old knows about fire and permanent injury. If he had done that, it might have been as easy as dealing with cross-examination. Sometimes the Commonwealth might have to get an expert. Sometimes the Commonwealth, for instance, in this case, might have been able to bring in evidence of what this particular child knew. But the danger...
But how does the Commonwealth do that? They don't know anything about this child, and the child doesn't have any obligation to tell them anything about himself, does he?
Well, that's correct, but the Commonwealth could indeed at least introduce expert testimony of a general nature.
Indeed, the facts of the case, the Commonwealth doesn't have to go out of its way to produce special expert testimony. The facts of the case can overcome the presumption.
Well, and
the conduct in the case can overcome the presumption.
And perhaps in a situation where the facts of the case were so clear that the presumption was rebutted, it would be rebutted just by the facts of the case, just by presenting them.
Well,
but
I have to say I find that a little peculiar, your position on that, because, for example, when we have a defense of criminal insanity or mental retardation or challenge, or somebody who's so intoxicated, which are similar. In other words, you're looking at, especially in a specific intent crime, then you get, the Commonwealth all the time has to overcome those defenses, and it does it in a regular way, sometimes by psychiatric testimony. It's seldom that we say, well, just the facts of the crime were so appalling. In fact, the facts of those crimes are typically absolutely appalling, and the defense is didn't know, mentally insane, mentally retarded, so intoxicated. That's absolutely standard, and we don't And so it seems to me that if you have a rebuttable presumption or defense of infancy, it's no different than those other cases.
But those cases are often overcome by the circumstances, evidence of planning, evidence
Well, of course, that's
of
different.
conduct after the, I mean, so you don't need expert testimony to rebut this.
I'm not saying you need expert testimony. I'm not suggesting that you need expert testimony, but how brutal the crime was itself. Planning, of course. It may be in this case, if it was an evidence, watching ants squirm and die. I mean, I don't know what the facts were, but it's not that difficult to imagine the kinds of evidence that would have to address this question.
Doesn't it make more sense, I mean, if there's any viability to your theory at all, doesn't it make more sense to put the burden on the child to come forward with some evidence that the unique circumstances presented in this child's mind suggest that, at least from a medical viewpoint, he did not have the capacity to commit the crime?
In that respect, Your Honor, I think this is quite different than defenses such as insanity or intoxication, because most adult defendants accused of a crime are not insane or not incapacitated by intoxication. However, most children share a certain developmental level. And I think if you look at, if all you really need to do to see what the problem was in this case is look at the sentencing report. Now, this obviously came after the child was convicted. But after spending just 2 hours with this child, the court clinic, the person who examined the child in the court clinic, was not convinced beyond a reasonable doubt that the child understood the consequences of his actions, and in fact said, I do not find him to be a sadistic boy, and it may be that he just didn't understand what would happen here. And that is the kind of evidence that should have been before the jury here. It was not, and that is why the case needs to go back to the juvenile court.
Thank you, Ms. Kaiser. Ms. Dillon?
Good morning, Your Honors. Diane Dillon, Assistant District Attorney representing the Commonwealth. Before I proceed, I think I would be remiss if I did not just raise an issue that was not raised on appeal, and that is whether or not the adjudication for assault and battery by means of a dangerous weapon is duplicative of the adjudication for mayhem. They have only claimed the appeal on the mayhem, but it occurs to me...
Can't be, can it? They're two different crimes.
Separate offenses?
There was only
Different
one
elements.
offense in this case.
Different elements, aren't they?
Well, there are additional elements that have to be proved, but I can't think of an element of assault and battery by means of a dangerous weapon that's not subsumed into the elements the Commonwealth
like a
was.
lesser included?
Yes.
Ms. Dillon, that's not in your brief, right?
That's not anybody's brief.
Yeah.
That's what occurred to me in the comfort of my home preparing for argument.
Sure. No, thank you for that. And perhaps what I might ask is for both of you to, if you choose to do so, to submit something to the court on that, because it's an interesting question.
Ms. Dillon, what about the element of dangerous weapon? You don't have to have a dangerous weapon in mayhem.
You don't, but in this case, the way it was charged, it was by means of a dangerous weapon that he did disfigure.
Good.
In this particular case...
It was charged that way.
It was charged that way, as the jury were charged that they had to find the specific intent to maim or disfigure. I think what's happened here is we're conflating the two concepts of capacity and mens rea. Mens rea is the specific intent to commit this crime.
Well, the difference is, at least in my mind, because I found your brief very helpful on that, is the specific intent to, where's my statute here, to disfigure, cripple, or inflict serious or permanent physical injury.
Yes.
And that seemed to me to be different than, clearly, than to...
Totally different concepts, Your Honor. The capacity is a common law concept that this rebuttable presumption had to do with criminal procedures. Juvenile law is not a criminal procedure anymore, and I think the state of Connecticut said it most well.
Well, I know we sometimes mouth the words that it's not a criminal procedure, but in fact, for whatever reasons, and Justice Cowen alluded to some of the on-the-ground facts, we've moved very much to a criminal system, and the consequences of being charged with a crime in the juvenile system is not the same, for example, as going off to the Department of Social Services or, in other words...
That may be an overbroad indictment, Your Honor. That was so when we first, I think it was 1906, and we began...
I'm just looking at the actual reality of the juvenile justice system now.
And there was a
Juvenile court.
retrenchment back in 1996, I think out of recognition that more and more juveniles at a younger and younger age were in fact committing more serious crimes, so the YO status was brought in and we can bring them back into criminal court.
But
That's
this
not
10-year-old got a suspended sentence, didn't he? To what? The Youth Service Board or whatever they call it now?
Yes, but then you're in the custody of your home. It's just to get services to the kids so that they can.
Well,
But suppose-
it's just to get services, but the consequences are very severe, because if they're then indicted as an adult, this service that is provided counts as a prior conviction.
But if they were brought in on a care and protection, Your Honor, or as a child in need of services, they might get the same service, so that they would get some guidance and some rehabilitation.
But that doesn't then count as a.
But if he messes up, this suspension gets revoked, and
It may.
he gets shipped off to DYS, where presumably they can keep him till what, 21, 18?
21.
21.
So he's facing a possibility of, he's probably
18, but don't they
18.
have some discretion?
possibility of 7-8 years of incarceration.
But that is the consequences of his act, and those acts and his consequences and his appreciation of it are something that would be brought to the attention of the juvenile court if and when that eventuality were to happen. In this particular case, he was in juvenile court, which is not a criminal session, it's a civil session, and as I started to say before, I think the state of Connecticut, its Supreme Court, said it best when they said that the delinquency system was a system-wide displacement of the criminal system. And in fact, if we were to use this rebuttable presumption, you could keep the kids, the children, that are most in need of these services out of the system that could provide the services, because they could come in and say, well, it's a rebuttable presumption.
The
these-
Connecticut case is instructive. It's also 20 years old, and the Maryland Supreme Court, for example, Court of Appeals, as it's called in Maryland, is a more recent case, takes exactly the opposite position and saying the reality on the ground is that there's no showing that they would be denied any services. These are, in fact, more like criminal procedures. They're adversarial, there's cross-examination, there's a right of confrontation.
Yes. I believe in Maryland there's also a codification of the infancy defense, which would distinguish it entirely from this case, because here in Massachusetts we do not have that codification.
We have a common law of the infancy defense.
If we were operating under the Commonwealth, I would agree with you. But we are no longer operating under the common law when we get into the juvenile court system and the delinquency system, because we're not dealing with a criminal concept, Your Honor. Our courts have gone out of their way since 1906, at least, to say that we are not treating children as criminals.
Do you agree that the defendant could have raised the issue of his mental
Absolutely.
state with psychiatric testimony?
Absolutely.
What would it sound like? I mean, he
It
doesn't
would
have a
sound
mental
just
disease?
like what it is. It would be just like an insanity. If this child were, as I've heard it put, so grossly immature, or if he had some cognitive deficiency.
Or just go to the sentencing report if it was clear that he didn't understand the consequences.
My reading of the sentencing report does not comport with her report of the sentencing report, and I'd also like to note that there was a pretrial report that was done on this child.
But can I just get back to that? Does it have the effect of an insanity defense, or does it have the effect of a diminished capacity?
We don't recognize diminished capacity so much in this state. The way I have heard it read by commentators is it's similar to an insanity defense, and that is that you cannot recognize the moral consequences, and therefore you should not face punishment.
Could the child then get sentenced to a state institute, or get committed to a state institution under Chapter 123, having been found not guilty by reason of insanity, or does the Commonwealth simply fail in its burden of proof on the element of mayhem?
I would suggest that it would provide the juvenile court with the option of, instead of committing him to a juvenile facility, giving him some other kind of service, because the juvenile has come forward with the reason that he did not conform his conduct to what would be a crime if he were an adult.
So the verdict or the finding would be not guilty by reason of insanity?
No, not
Not guilty by
I would
reason
say
of mental
it would still
illness.
result in an adjudication of delinquency, but the judge who is charged with doing what's best for the child, instead of committing the child to a facility that you may or may not consider to be similar to a penal facility, would choose another option to get the rehabilitative services that our system is supposed to deliver to children of that age when they commit offenses like this.
Well, I mean, but Justice Spina raises an interesting point. If, for example, the judge, let's assume it's a judge trial for the moment, it could be a jury trial, is, you know, there's some charge that says, you know, I have, because of my youth, I am unable to appreciate the consequences. I think you find that the Commonwealth hasn't met its burden, and therefore you don't have a finding that mayhem was committed.
That might happen.
If you have a finding that he's not delinquent, if it goes in that direction, and then it's up to the social service agencies to look at the family and look at him and decide whether he needs care and protection services and all that kind of rigmarole.
This is precisely why, Your Honor, many commentators have said that maintaining this presumption in the context of delinquency systems could thwart the very purpose of the juvenile court.
There's no suggesting that there's no alternative. It's partly because we have a hybrid in this Commonwealth. There's nothing to suggest that this child couldn't be given the services. In other words, nobody's suggesting that the court doesn't have jurisdiction over the child.
I'm not suggesting that, Your Honor. I'm saying that has to do with the disposition after an adjudication that this child is in need of the services that the juvenile court system is charged with delivering.
You
What
mentioned
are most states doing on this presumption?
Most states, as far as I can see, and it's been stated that most states are abolishing the presumption because the presumption is something that goes with the common law and the juvenile delinquency proceedings are not. I note in your book that you have several footnotes about the progress of the state. I have not noted in the research that I did in preparation for this that there is the retrenchment. The only thing that I noted is that some of the older juveniles are becoming more susceptible.
Have you read the amicus brief that was filed by the...
Yes, I have.
Yeah.
And there, at least, they suggest that there is a retrenchment. In a sense, as the juvenile system went more and more to giving services to children...
But they're citing Galt, Your Honor. That's 1961 or something. So to suggest here, in 2007, that we have failed in all of our efforts, and we've made mighty efforts here in the Commonwealth. Since the mid-'70s, we've changed it and changed it.
If we say the presumption's in effect between 7 and 14, would it carry over to adult court?
I don't think it would carry over to adult court because we don't bring a juvenile into an adult court until they're 14. But I do think that it would apply to every juvenile case.
If a 13-year-old commits first-degree premeditated murder, and there's some of them that are capable of that,
yes,
believe me, as you know, and is bound over to be tried as an adult. Can he be bound over and tried as an adult?
I think you have to be 14, Your Honor.
Minimum 14.
Yes,
so he
Your
would
Honor.
be tried in the juvenile system.
Doesn't that indicate something?
I think it
in other words,
indicates
the
that
common
we
law
try
was-
mightily and we have to draw bright lines.
No, I understand, but it's interesting to me that Massachusetts wasn't out of kilter with the rest of the world with between 7 and 14, below 7, over 14, and when the legislature, which surely had before it evidence of really horrendous things that children do, sometimes 13, 12, 11, 10, or in this case, put the treatment as an adult at 14.
That was in 1996. That was after we enacted the juvenile system that is in place, except for the YOs. So as I say, this is a slight retrenchment that is based not so much, I would suggest to you, on what we do in the juvenile justice system, but unfortunately what happens out on the streets and what we have to cope with. And the juvenile justice system cannot cope with that kind of, sometimes, or you can't call them sociopaths until they're 16, but they may very well be, we just can't label them as such.
But the judge here could have sentenced him. I mean, I know she suspended the sentence, but she could have outright sentenced him to DYS, correct?
She could have.
And he would have spent 7, 8 years there, possibly.
She could have sentenced him to a year or 6 months. She could
Yeah.
have done a lot of things based
Well,
on
may
the
I- may I- The
Yes.
juvenile judges don't have sentencing power. They can commit to DYS.
Thank you, Your Honor.
End of discussion.
Yeah, they can't commit them for defined time, I don't think. I think
Right.
once they get there, it's up to DYS to figure out when to let them go.
So if DYS were in fact to deliver the services that they're charged with delivering, he might be back home in no time flat.
You might not either.
The
But
pre-sentencing...
that would have to do with him and not the commitment that the
Stella, let me
judge...
ask you this. We have various rules that apply to children, and it struck me, for example, contracts, schools are now teaching accounting, they're teaching all kinds of things. People know about contracts, but we just avoid them. Second of all, and more seriously, is tort claims. If the child is under 14, people can get terribly harmed, and we just say, if you're under 14, because it's a child, you can't be held accountable, and yet the very serious consequences of being adjudicated a delinquent, you're saying are somehow different.
No, Your Honor, I'm also going to suggest to you that the restatement of torts says that any child who is of an age to be let at large should appreciate the dangers of water, fire, and heights. Now, this child was at large, and he should have appreciated
I don't understand how that's responsible. You say he should appreciate it, but we don't know that. Because, and you may be correct, we don't know that because it wasn't part of this case. Essentially what you're saying to me is the restatement of torts has turned it into a rebuttable presumption.
I don't think that's what I meant to say, Your Honor. Perhaps I misspoke.
I'm just curious about this pre-trial examination that you've alluded to and you mentioned in your brief. By whom was he examined and for what purpose?
By the court clinic to see if he was competent to stand trial. I'm suggesting to the court that the very fact that he did stand trial under Moran gives rise to a rebuttable presumption that he was competent to stand trial.
But competent to stand trial is very different.
It is. But it also suggests that there is no gross infirmity here.
But you could be competent to stand trial, and the trial could result in an insanity verdict.
Absolutely, yes, Your Honor. But you asked if this would apply to all juvenile cases, and if we were to apply that rebuttable presumption, it would have to apply to all juvenile cases when the juvenile is under the age of 14.
And I assume what happens now in an under 14 case against a juvenile who's tried for first-degree murder in the juvenile court? Is there any presumption?
I can't speak to that, Your Honor. I have tried them in Superior Court. I have not tried them in juvenile court.
Thank you, Ms. Dillon.